Presenting the motion, Senator Sekibo, a member of the opposition People's Democratic Party (PDP) representing Rivers East, said letting the court judgment go without consent will become a precedent. He then urged the National Assembly to appeal the judgment of the Federal High Court (ABIA), which nullifies Section 84, subsection 12 of the Electoral Act 2022 as amended after being established by the National Assembly.
The Senate believes that the Senate of the Federal Republic of Nigeria should show concern on the judgment, especially when she was not given opportunity to represent herself in a matter such as this that emanates from her legitimate functions. The Senate finally believes further that letting the judgment to go without concern will become a precedent on which any person could go to the court and obtain judgment to ridicule the good intentions of the National Assembly as an institution. The Senate accordingly resolved to 1. Follow the appropriate channel and appeal the judgment in suit marked FAC/UM/CS/26/2022 for the court to set aside the judgment, as the judgment was reached without due consideration of the constitutional interpretation in Section 318 of the 1999 Constitution as amended.
Supporting the motion, Senator Sabi Abdullahi, a member of the ruling All Progressives Congress (APC) representing Niger North, urged his colleagues to consider the motion as submitted.
Of course, in seconding this, Mr. President, distinguished colleagues, let me add that the content of the motion is straightforward, is clear enough, and the resolution sought is also clear enough. And therefore, on the basis of this, Mr. President, distinguished colleagues, I want to urge that without much ado, I invite and request humbly that my colleagues do consider this motion as submitted, and to say that we ask that the question be put for us to consider the prayers.
Recall that Justice Evelyn Anyadike of the Federal High Court (ABIA) ruled that Section 84, subsection 12 of the Electoral Act is unconstitutional, illegal, null and void, and of no consequence, and therefore ought to be struck down, as it is in violation of clear provisions of the Constitution. Consequently, the court ordered the Attorney General of the Federation to forthwith delete the contentious section from the body of the Electoral Act. The contentious section reads that no political appointee at any level shall be a voting delegate or be voted for at the convention or congress of any political party for the purpose of nomination of candidates for any election.